Committee study of the Central Intelligence Agency Detention and Interrogation Program is a report compiled by the bipartisan United States Senate Select Committee on Intelligence, or otherwise known as SSCI, about the Central Intelligence Agency's Detention and Interrogation Program and its use of torture during interrogation in U.S. government bulletins on detainees in CIA custody. The more than 6,700-page report, including 38,000 footnotes, details the history of the CIA's Detention and Interrogation Program and the committee's 20 findings and conclusions. On December 9, 2014, the SSCI released a 525-page portion that consisted of key findings and an executive summary of the full report. It took more than 5 years to complete. The full unredacted report remains classified. Today's summary: after passage of the Detainee Treatment Act, OLC opinions on CIA conditions of confinement, withdraws opinion on the CIA's enhanced interrogation techniques after the U.S. Supreme Court case of Hamdan versus Rumsfeld. On December 19, 2005, anticipating the passage of the Detainee Treatment Act, acting CIA General Counsel John Rizzo requested that the Office of Legal Counsel review whether the CIA's enhanced interrogation techniques, as well as the conditions of confinement at CIA detention facilities, would violate the Detainee Treatment Act. In April 2006, attorneys at the Office of Legal Counsel completed initial drafts of 2 legal memoranda addressing these questions. In June 2006, however, the U.S. Supreme Court case of Hamdan versus Rumsfeld prompted the Office of Legal Counsel to withdraw its draft memorandum on the impact of the Detainee Treatment Act on the CIA's enhanced interrogation techniques. As blank CTC Legal explained, the Office of Legal Counsel would prepare a written opinion if we want, but strongly implied we shouldn't seek it. As described in a July 2009 report of the Department of Justice and of Professional Responsibility, the administration determined that after the Hamdan decision, it would need new legislation to support the continued case of the CIA's enhanced interrogation techniques. Even as it withdrew its draft opinion on the CIA's enhanced interrogation techniques, the Office of Legal Counsel continued to analyze whether the CIA's conditions of confinement violated the Detainee Treatment Act. To support this analysis, the CIA asserted to the Office of Legal Counsel that loud music and white noise, consistent light, and 24-hour shackling were all for security purposes, that shaving was for security and hygiene purposes and was conducted only upon intake and not as a punitive step, that detainees were not exposed to an extended period of white noise, and that CIA detainees had access to a wide array of amenities. This information is incongruent with CIA records. Detainees were routinely shaved, sometimes as an aid to interrogation. Detainees who were participating at an acceptable level were permitted to grow their hair and beards. The CIA had used music at decibels exceeding the representations to the Office of Legal Counsel. The CIA had also used specific music to signal to a detainee that another interrogation was about to begin. Numerous CIA detainees were subjected to the extended use of white noise. The CIA further inaccurately represented that medical personnel will advise ending sleep deprivation in the event the detainee appears to be experiencing hallucinations, transient or not. In a May 18, 2006 letter, blank CTC Legal, blank, wrote to the Department of Justice that some of these conditions provide the additional benefit of setting a detention atmosphere conducive to continued intelligence collection from the detainee. While the letter referred generally to consistent light in the cells, use of white noise, use of shackles, hooding, and shaving, barbering, it described an intelligence collection purpose only for shaving, which allows interrogations and interrogators a clear view of the terrorist detainees' facial clues. On August 31st, 2006, the Office of Legal Counsel finalized 2 legal analyses on the conditions of confinement at CIA detention sites. The first was a memorandum that evaluated whether 6 detention conditions in the CIA's detention program were consistent with the Detainee Treatment Act. The second, provided in the form of a letter, concluded that those same 6 conditions did not violate the requirements of Common Article 3 of the Geneva Conventions. The Office of Legal Counsel relied on the CIA's representations related to conditions of confinement for its analysis. The Office of Legal Counsel wrote that underlying our analysis of all these methods is our understanding that the CIA provides regular and thorough medical and psychological care to the detainees in custody. As detailed in this summary, the lack of emergency medical care for CIA detainees was a significant challenge for the CIA. The August 31, 2006 Office of Legal Counsel memorandum applying the terms of the Detainee Treatment Act to the conditions of confinement at CIA detention facilities stated that over the history of the program, the CIA has detained a total of 96 individuals. This was based on a representation made by blank CTC Legal on April 23, 2006. As of the date of the Office of Legal Counsel memorandum, the CIA had detained at least 118 individuals. The Office of Legal Counsel memorandum also stated that we understand that once the CIA assesses that a detainee longer possesses significant intelligence value, the CIA seeks to move the detainee into alternative detention arrangements. CIA records indicate that detainees had remained in CIA custody long after the CIA had determined that they no longer possessed significant intelligence. Finally, the Office of Legal Counsel memorandum repeated a number of earlier inaccurate CIA representations on the effectiveness of the program, citing both the CIA's effectiveness memo and its own May 30, 2005 memorandum. Notably, the August 31, 2006 Office of Legal Counsel memorandum repeated the same inaccurate representation which first appeared in an August 2002 Office of Legal Counsel memorandum that Abu Zubaydah was al-Qaeda's 3rd or 4th highest ranking member and had been involved in every major terrorist operation carried out by al-Qaeda. As described, CIA records as early as 2002 did not support these representations, and 2 weeks prior to the issuance of the August 2006 memorandum, the CIA had published an intelligence assessment stating that Abu Zubaydah had been rejected by al-Qaeda and explaining how the CIA had come to miscast Abu Zubaydah as a senior al-Qaeda lieutenant.